Volume 3, exercise number 12, start. Challenge in this appeal is to the judgment of a division bench of the Calcutta High Court, disposing of the writ petition, the appeal and the application filed with certain modifications, full stop, on the allegations that there was insertion of a variant employment in the meter of bypass recording of actual consumption, first information report was lodged by the personnel of the appellant board, full stop. The provisional assessment was made and thereafter there was disconnection of electricity supply, full stop. A writ application was filed by the respondent number 1 making grievance that the disconnection of the supply was wrongly done and the provisional assessment, as made claiming rupees 2,50,046 on the alleged ground of theft of electricity and slash or tampering of the meter, was not sustainable, full stop. Next para. Learned single judge of the Calcutta High Court disposed of the matter in writ petition, whereby and whereunder the appellants were directed to restore electrical supply on deposit of rupees 20,000 by the writ petitioners, full stop. The appellants questioned correctness of the order on the ground that the disconnection of supply line was effected on 24/1/2006 in terms of the Regulation 52 of the West Bengal Electricity Regulatory Commission, full stop. The division bench referred to Regulation 52 and observed that the appellants have got right to disconnect supply line of electricity on fulfillment of the conditions stipulated, full stop. But the same is required to be done following a particular procedure, full stop. It was held that due procedure was followed, full stop. The division bench held that under section 126 of the Concerned Electricity Act, 2003, the writ petitioner had a right of filing an objection thereof, which has been filed by the writ petitioner under section 126 under bracket 2, full stop. The appellants are required to pass a final order after giving a reasonable opportunity of being heard, full stop. The writ petitioner also has a right to prefer an appeal under section 127 of the Act against the final assessment order, full stop. The division bench, therefore, permitted the parties to pursue the remedy, full stop. It was, however, held that the disconnection of power supply was contrary to and was in breach of Regulation 52, and the writ petitioner was therefore, entitled to be compensated, full stop. Accordingly, the cost of rupees 25,000 was imposed, full stop. Next para. Learned counsel for the respondents submitted that the High Court has taken note of the factual scenario and the legal principles applicable, full stop. The final assessment in any event is the subject to challenge, full stop. Since the final assessment has been challenged, we feel interest of justice would be best served, if the same is disposed of in accordance with law, full stop. It is open to appellant board and its functionaries to highlight before the concerned authority as to the maintainability of the appeal on the ground of alleged delay full stop. It is needless to say that the said aspect shall be considered by the appellate authority full stop. Let the appeal be disposed of in accordance with law without being influenced by any of the observations made by the High Court in the impugn order and by learned single judge. Full stop. Thank you.